yo voy a hacerte el amor en la cama, porque tú sabes que tú eres mi dama. Ey, tienes días que te gustan, tú sabes que tú eres mi princesa. Yeah, yeah. Vente pa' acá, mamá, tú sabes que yo soy tu nana. Quiero atentarte en mis brazos, darte lo que quieras, mi amor, no perdóname. Saliendo todos los días con mi pana, fumando marihuana, bebiendo y pimpeando, jangueando. Yo sé que eso a ti no te gusta. Saliendo todos los días con mi pana, fumando marihuana, bebiendo y pimpeando, jangueando. Yo sé que eso a ti no te gusta. Tú y yo, en la cama tú y yo, quiero hacerte el amor. En la cama tú y yo, quiero hacerte el amor. En la cama tú y yo, hasta el amanecer, quiero hacerte el amor. Tú y yo.
All right, well, we'll get started. I'm gonna grab this for a second. We're at the Just the Basics client management here. We've had, I think, about 30 plus of these over the years, and it's been a really good way for our younger practitioners. And I consider you guys all younger, maybe because I'm getting older too, right? But our younger practitioners, giving them a chance to show what they know in an easily digestible way. I know we're going to have a lot of people watching this on demand close to the end of the year. So this is for their purposes as well. We'll have 1 hour of CLE credit. If we go on, I'll put up more CLE credit. But in general, client management is just so important to what we do on a day-to-day basis. We have 4 different practice areas here represented, and they all have great information on how to hopefully set yourself up for success and avoid burnout and things like that. We've put together a little bit of an outline, which you have here today. I think we have well over an hour of things to talk about. So I want to turn it over to you all. And for this first round, let's start on this end and go down the way. We have Tiffany Beerman of Dvorak Law. Welcome, Tiffany. We have Kyle McGinn of Hauptman, O'Brien, Wolf and Lathrop. We have David Pontier of Koenig Dunne, and we have Mallory Hughes, Very Law, here today. So I'll let them do a quick intro of themselves and their practice areas. And then we'll start with one tip, just generally off the top, not focused with anything of the outline, but one tip on client management that really sticks into your head that you want to start with, okay? So take it away, Tiffany.
Perfect. So my name is Tiffany. I'm a 2018 graduate of Nebraska Law. I practice primarily in commercial litigation. I do some advising relating to insurance and other sorts of business matters. However, I primarily practice just commercial litigation, kind of all over the board on just various different items, but primarily representing businesses, business owners. I do some individual work as well. One tip relating to client management, kind of off the cuff, and I think one of the most important things is communication and over communicating with clients. The one thing that really can make a client mad is the failure to communicate, and it kind of just saves you, if you over communicate, communicate ideas, communicate what you're thinking, get approval from the client. So it's just over communicating, I think, is one thing that is my one tip on things to do to make a client happy.
Good afternoon. I'm Kyle McGinn. I previously worked for a general practice firm in Council Bluffs, Iowa for about 7 years. So I've done all sorts of different kinds of work. For the last 2 years or so, I've done purely plaintiff's personal injury at Hauptman O'Brien here in Omaha. I have myriad of experience, but almost all of my clients have been individual persons. So maybe unlike Tiffany, I don't have a lot of institutional or corporate scale clients. So it's a little bit of a different experience, I think, as it comes to client management when you're working with Joe or Joanne off of the street. I think many of you probably have shared in that experience, just a little bit different calibrated experience. I think if I have one tip for you, it's that your client will immediately latch onto the first expectation that you set. And regardless, 6, 12, 18, 24 months later, when you're resolving that matter, you know as well as I, they are not going to forget that very first expectation you set, whether that was at the first consult or somewhere early in the process. You may hope that they have forgotten when you get to the conclusion of their matter and it doesn't quite match that expectation that you offered quite at the outset, but just understand they are not going to forget that. Thank you.
Hi, my name is David Pontier. I'm a partner at Koenig Dunne. I practice exclusively in family law, doing divorces, modification of custody matters, paternity cases, adoptions for a happier note. I've been in practice since 2017. If there is, I guess, one tip, that I would give more than anything when it comes to client management, investing in a successful relationship with your client at the beginning of the case, frankly, from the first moment that you start working with that client. And I mean, that doesn't have to be you're a best friend to your client, right? But like Kyle had mentioned, I practice exclusively with real people, right? And so letting them know that I see you as a human, I can empathize with you, and I'm here to help and I care, right? Building that rapport from the start, because that helps later on when there are challenges on a case, when things may not be going well, when there are tough decisions to make. If you built that trust and that rapport with the client, it pays dividends later on.
My name is Mallory Hughes. I graduated University of Denver, Sturm College of Law in 2010. I worked doing criminal defense primarily. I also did divorce for 5 years and realized that I am not cut out for that. So God bless you. At Dornan Law Team, I was at for 10 years, and then I've been with Berry Law since 2021. My practice currently is almost exclusively felony criminal defense. Tried over 30 cases in the past 14 years. A lot of my potential new clients are facing decades or life in prison. So my tip in that practice area, I guess specifically, is managing client expectations from the outset, not ever guaranteeing anything because you don't know what's going to happen, and just letting them know what they're facing, what potential options are, and a game plan kind of out of the gate so that there's some comfort that, okay, my attorney, this is what they plan to do. These are the action items, kind of letting your client know, here's what we're going to do. I can't guarantee you anything, but offering some action items out of the gate as far as what to do and setting some expectations.
So let's dig into that initial time with client, as we'll just kind of say a little bit more about how you set those expectations. Is it do you have letters that you're sending out that have this information there? Do you see where they're at and change your communication based on where they're at, if they're a texter as an emailing, and also how do you set that dynamic? I know everyone has sort of their own different way of making sure that they understand how their relationships go. I'll open up to anybody who wants to. Please.
I can start. So with respect to communication, what we do initially is, we will try to set expectations up front, because I think in the commercial side, the biggest thing is attorney's fees. That can make or break, not even strategy. It's, the client happiness with really your work. So we try to upfront set expectations on what the cost is going to be on recommended different strategy approaches. With commercial litigation matters, if our clients are getting sued, we like to send out estimates from the get-go on, here's all the different things that we need to do, for the pleading stages, and here's, different strategy approaches with pleadings, through discovery, through, pretrial matters and summary judgments, all the way through trial. And what we try to do, we try to strive on, with keeping the clients happy. We will always try to communicate with the clients in the way that the clients want to be communicated with. So if the client prefers to text or email or phone call, we will make that accommodation. We give our clients our cell phone numbers. We strive to be available whenever possible for our clients, within reason, obviously. But that's typically what we try to do. And we set those boundaries up front. We try to learn that initially, from the initial client call. And as litigation progresses, we'll also try to make sure that we update our budget as it goes forward. So if we're already hitting the pleading stage and we're hitting, the upper end of our budget, it's really important to reach out to our clients in advance and say, hey, we're getting close to where we're going to hit, because it's better to warn them in advance that we're going to go over or we're getting close than going over and either writing off your time or telling the client that the bill's a lot more expensive because we misestimated from the get-go. So.
Well, you're kind of in a different boat on that, aren't you?
I am.
A lot.
I am. David, I think as soon as I realized that we're a highly credentialed service industry and that there's little that separates us from any other service industry, I think that's when I started getting better at this. That's not to diminish the professionalism that I think is there and should be there. But like any other service, if I call out a repairman to my house to fix my gutters after a windstorm, I want to know the same two things. How long is this going to take and how much is this going to cost me? I think that's an exceedingly fair question. I try to focus on the process. Obviously now I'm in a unique position because I don't necessarily require a retainer or a flat fee from somebody up front, but I've worked in all sorts of those capacities, so I'm acquainted with that. I think it's critical that you offer some kind of answer, because I know that for almost all of us, that prospective client, unless it's a longstanding client, or maybe even if it is a longstanding client, they're going to talk with 2 or 3 or 4 or 5 other people, and that's fine. So I'm careful to offer too specific of a prognostication about how something's going to end up. I do want to talk about procedure and try to do that in a way that's approachable. I'm not going to talk with them about a summary judgment motion. I'm going to talk with them about a phase in their case where a judge is going to decide whether we survive a legal standard and move forward. Maybe with a more sophisticated client that's used to being or is accustomed to being in a litigation process, that's a more appropriate way of handling that conversation. Similarly, if you're dealing with your clients who are often, I'm supposing, one-offs or maybe have had some experience, but it's probably remote in time, you've got to reacquaint them to the language of the process as well. So I think maybe as soon as you kind of let your hair down and realize this is a service industry, they're going to weigh you against others. You need to come up with something to respond to them, because when you're asking them for a significant amount of money and to trust them in an impactful process in their life, what they don't want to hear is, I have no idea how much this is going to cost, and I have no idea how long this is going to take. So you have to have something informed to say to them. I think that's not too specific, that's in the range of reasonableness. If you don't know what that range of reasonableness is, you better get acquainted with that. Or you should have somebody in that room who can help offer a better projection on where things are going to go. If you're maybe a solo practitioner, that probably means reaching out to somebody in your community or finding a mentor that can offer you better advice about how the matter is going to unfold, because nobody wants to be the initial trial run. And I think that's fair. They're offering you good money for your service. So maybe focusing on the process and cluing them into how that's going to look as opposed to a specific outcome estimation is preferable, and educating them about how that's going to unfold.
Yeah, Dave, with respect to setting expectations for communications, our firm has invested heavily into developing systems for how is that going to look for our clients from day one, minute one, right? And, if you schedule a consult with us, even before you come in, right, there's information that we're asking you to provide and information that we're giving you. And as part of that information gathering, portion of meeting you, right, it's asking you, what's your preference for communication, right? Do you want more? Do you want as necessary? Do you never want to talk to me at all unless you absolutely have to, right? And I think it's fair for us as attorneys to let our clients know we have a preference too for communication. It's much easier for me to respond if it's, if you have a lot of questions that require, just a lot of thought. If you can get me those in an email, right? If it's important to you to have a weekly update on your case, if it's not me that has the capacity to do that, there might be another team member on our team. Maybe it's my paralegal or somebody else who can, right? So to answer your question, Dave, yes, asking the client what is important to you as far as communication and doing our best to meet that, but also setting boundaries too, to let clients know that this is what we're capable of doing. And what I've found is that if you are upfront and honest with clients from day one about what you can or can't provide for them as far as communication. As long as you stick to that, I think most clients are happy with that. You know, if I tell a client that I will make you a promise that there will not be 48 business hours that go by where you don't hear from me or my team. It might not be the next minute that you email me, right? It may be, you know, after a weekend, right? But if they know that and you stick to that promise, right, I think clients are happy with that because they understand that that's the expectation and that's what's being met.
Yeah, I agree with all the comments so far. In terms of talking about retainers and the money we're asking for up front, it's a lot. So at Berry, we take a team approach and we explain that to the client, particularly on criminal defense. We always try cases with 2 attorneys. With these serious felonies, the prosecution's always going to have 2 prosecutors. And I mean, they've already got way more resources than us, so try and get yourself on as close to a level playing field as you can. So we explained that to the client, but what does that mean for your case? Why are we asking you for this huge retainer? Well, if I'm in trial, but Paul's also working on your case, you can get Paul on the phone and find out an update. Oh, by the way, we've got a paralegal. Oh, by the way, we have we have this whole criminal defense team that is working on your case. For that reason, we're different than most criminal firms. Most of our cases are hourly. A lot of criminal attorneys do flat fees, but because we have so many players involved, we're doing hourly so that it's fair for the client. They're seeing, you know, what's happening in that regard. But also walking through, you know, we've been doing it long enough to know, okay, when this kind of case comes in the door, I'm going to probably have half a dozen depositions. I'm going to have to pay court reporters for those transcripts. Probably going to have a series of evidentiary hearings. Probably going to need a psychologist to take a look at some stuff. Might need a psychiatrist to look at this video and tell me if there's any issues with the interviewing style. And so walking the client through, if you want the best defense and you want to leave no stone unturned, it's not cheap. And like other industries, you get what you pay for. Yeah. There might be someone out there who will take your case for, you know, X amount flat fee. What are they going to do with that money? And so we kind of walk through, you're going to see what we're doing with your money every 0 to 6 minutes. I see you guys do hourly probably for the most part.
0 to 6 minutes.
Yes. Okay. But also acknowledging this is a lot of money that I'm asking for. I'm not saying this is going to be easy to come up with overnight. And here's how some people pay for it. Some people take out lines of credit. Some people 401k. Again, these are, for us, it's people's lives. I mean, a lot of the cases we deal with are up to life in prison. But so empathizing with the amount, but explaining why it is that amount up front, I think is really important. And walking through where that money is going to go. You know, this first phase of the case, we're going to get a private investigator to go do X, Y, and Z. Again, specifically for our, you know, a lot of our clients are coming to us in the worst situations in their lives. They want something to do. And a lot of times there's nothing to do right away because we've got to wait for a preliminary hearing, get into district court, get discovery. So it's okay, go put together a timeline. Write attorney-client privilege at the top. Do not share this with anyone. Do not talk to anyone. So the do's and don'ts, and just kind of like, what can you do to help your case out of the gate? And I mean, the reality is there's very little, but are there people we should go interview? Is there a phone where we should do an extraction with our digital forensic expert? Giving the client some things where they can help and start to be involved, because while it's just one of my 40 or so clients, this is their whole life right now. So giving them something to kind of contribute out of the gate. Yeah.
I love that we all were talking about team, right? And utilizing the team. So you may be the primary attorney, but there are staff members, there are other people that will be communicating and being part of this management of the client to communication. That's not everywhere. That's not every firm. That's not every consultation select this. So in terms of updating them on their case, how often, how much information, things like that. Is there a way that you found is effective, and is it effective in updating them? And then any war stories lead to fall?
I think generally, you know, what I like to try to do, I mean, it kind of depends on client need, you know, even though I primarily do work for businesses, there are certain business owners who are more needy or want to know what's going on more than other business owners because, you know, they're individuals, people too. You know, at a minimum, I like to update the clients before a bill goes out, right? So the way that we bill, we like to tell the story in our billing descriptions because they're paying for us and want to know what we're doing and want to know that it's worth it. So, but it's nice to get an update out before the bill goes out to the client, because you don't want the client to get a significant bill and be like, you would never talk to me about any of this. So that's at a minimum. I like to just update the client then, even if nothing's gone on, because in litigation, there's plenty of times where a month will go by and nothing happens. So that's at a minimum, but there are clients who want to be updated more. And kind of like the panel was discussing earlier, there are other team members at my firm that can easily help out on updating the client, whether that's my assistant or, another associate on the matter or a partner or anybody. The client knows all the contacts on their file and on their case and who they can contact to get an update. So those who want it more, we'll do a phone call, we'll do more emails, kind of update them more periodically. It really just kind of depends on what the client wants and what, kind of matter is happening. Is this a one-off project? We're doing a research project for a business where they need to know something before taking a certain action, or is this ongoing litigation where it just inherently takes longer? So that's the approach that we like to take generally.
I, like many of the participants here today, went to Nebraska for law school, and I recall in legal professional responsibility, I assume this is the same at Creighton or in Denver, the then counsel for discipline came and presented to us and said, the number one complaint we get is that people don't call or email back. And as I was sitting there as a second-year law student, that seemed so basic to me. And then you get embroiled in 50 cases, 100 cases, whatever it may be, and you realize how onerous that may become. I try to similarly probably time schedule to touch base with everybody at least once every 30 days. Like you had said, there may be nothing going on in any particular case at any given time, and you're on the cusp of trial, and all your energy and attention is focused here. It's hard to remember that John or Jane Doe over here, this is the only matter that they've ever been embroiled in. And while you know that their matter is just simmering, it feels to them like a 5-alarm fire. And to make them feel heard, and I appreciate you've got colleagues that can kind of step in and take some of the brunt of that for you. I think eventually at some point, we're the commodity, and they want to know that we're thinking about them. So, even if that's a 5-minute call or an email or whatever saying, I'll get back to you next week. I'm in the midst of something. Please talk to my colleague if you have a question in the interim. Great. Just knowing that they're being thought about can go a heck of a long way, I think, particularly if they're about to receive an invoice and don't understand that maybe there's been things going on in the background over the last couple of weeks that they haven't been as acquainted with. And knowing your client, I think, is critical to that as well, to the level of attention that they need to feel comfortable and to feel seen. I guess that's a popular term these days, to feel seen.
Yeah, similar to Kyle, we have a system in place that just reminds us, you haven't spoken with this client in 45 days, touch base, right? And maybe it's not even about their case. We're just checking in with them. How are you doing, right? Dave, to answer your question, right, how soon do you communicate about, information? Well, I think a lot of that depends on what's the information that you have to communicate, right? And in divorce practice, you have an adversarial practice where the parties are still communicating with one another, right? And if you have a trial order or a temporary hearing order that comes down and your client is learning about the results of that from their soon-to-be ex-spouse, right? You are going to be in some hot water as a practitioner. So, for if you get a trial decree, if there's any kind of litigated order that comes out, you are immediately talking to the client, right? If you go to a hearing, there are little status hearings, discovery hearings, things like that, small hearings that clients may or may not attend, right? If they're not there, I'm immediately calling them, letting them know this is what happened at that hearing. And I always prefer to do a phone call for that, unless a client has a real objection to you giving them a buzz, right? Because usually there's a lot of back and forth questions that you answer about hearings and the litigation process that you're trying to explain to your clients. To your point, though, Dave, maybe not all information has to be shared exactly immediately with your client, right? Like if you got, maybe a settlement letter that is really going to upset your client and it's the day before Christmas Eve or something like that, maybe you wait until the following Monday to send that one out, right?
Send them the settlement. Each one that comes in, you have to send it to them, right?
You have to send it to them, but maybe, we'll wait until the weekend is over. If I'm in trial the next day and I know they're immediately going to be calling me, strategically making sure it goes out when I'm available to be able to take questions, right? So yeah, thinking through can I answer questions immediately if this is going to be something I know my client is going to want to ask about. But and the last thing I would mention too, I do think there is a fine line, right? For the just very routine, there isn't a substantive decision that a client needs to make on a case. This is just the standard way we file motions or whatever, right? That's a part of your practice. There is you can't inundate your client with too much communication, where eventually they look at you and they say, well, you're the attorney, you tell me, right? So substantive questions, things that impact your client's case, even big litigation decisions or big cases, all of those things you need to involve your client in. But more of the routine, how do we practice, those smaller items. I think maybe informing clients about them, but again, having them, building that relationship like I talked about, that they trust you, that yes, we're doing this correctly for your case.
Yeah, with criminal defense, our cases move probably faster than any of the other cases up here because of speedy trial and things like that. So organically, we're in pretty frequent communication because between the pre-trials we have and trial and all that kind of stuff, we're pretty routinely communicating with our clients. What I like to do that's a really beneficial tool is I just have an Excel sheet for myself that I update every Sunday. It's got the client name, who I'm working on it with, so which paralegal, which attorney am I working on it with, case status, location, how much money is left in trust, right? Because if you've got $500 left in trust and you've got jury trial in 60 days, it's not going to cut it at all. So I update that every week, and what that helps me do is I've got the clients that I'm organically communicating with because, hey, we just had a pretrial, we just had this ruling, we talked 5 times this week. But then I have some clients who haven't even been charged yet. We're under investigation. And a lot of my cases have no statute of limitations. So a lot of times investigations can last months, years, and there's no movement. And I'm not going to bill the client to every single week, hey, no updates, I'm not going to do that. But you do need to check in every now and then. So doing this spreadsheet once a week kind of reminds me, the last time I emailed with this client was, 60 days ago. It's a pre-file, haven't heard from the detective, haven't heard from the client. So sometimes I'll just checking in, assume no news is good news, but do you have any updates, kind of a thing like that. So keeping like your own personal thing like that, where you just update the main data on your own weekly can be hugely beneficial, I think. We do a lot of phone calls with our clients because a lot of stuff you kind of need to talk through, followed up immediately by an email. To follow up, here's the high points. We're talking, plea versus trial strategy. For our conversation, we think you should counter with this plea offer. You said no deals, we're going to trial. Please confirm that's what you want to do. We need that kind of stuff in writing.
There is an email with all everybody in the conversation.
Not any conversation, but a lot of substantive stuff. Yeah. So whether it's like, we have a case going to trial in 4 weeks, and we think we can secure a phenomenal deal if we counter, and our client is not approving any offers. That's against our advice. We're going to document that and say that's fine. And when we're communicating with him about this, we'd say, look, we understand you want to go to trial, and we're ready to go. We love going to trial. It's our favorite thing. We think you should let us make this counteroffer because we think this would avoid some potential risk, but we're ready to go to trial. We do need you to confirm in writing that you do not want us asking for this resolution because he's convicted and he comes back, so we do a lot of follow-up in writing, but also because a lot of stuff is complicated. If we counter with this offer that we discussed, let's say they want to do a counter, you would be facing 0 to 3 years in jail. With good time, that's 18 months. You would also be facing sex offense registration. You would also be, here's all the consequences. Do you want us to counter with this offer? Yes, boom, pull the trigger and send the offer, kind of a thing like that. So we do quite a bit of follow-up, again, because a lot of it's complicated. And while the client understands, I think it's nice for them to have in writing, okay, here's the high points of the 2-hour conversation we just had, whatever.
So the rest of you, is it sometimes, yes, an email follow-up on a phone call, always?
I would kind of agree. I kind of take the same strategy of like really important decisions. You want the client to agree with those in writing because I think some of the biggest horror stories come out of, you take a certain position after you talk to the client on the phone and the client agrees on the phone. And then after that position doesn't work out, you lose a summary judgment and it costs you a significant amount of money, or you go to trial and you lose. The client's mad about strategy. And so it's always really good to have the client agreeing in writing, or at least you have something in writing where you say, here's the pros and the cons of each approach. We discussed this over the phone. Please confirm that this is the position that you want to take. So I would totally agree that that is, the right thing to do, and that's something that's consistent in commercial practice that we like to do as well. So
I'd be curious, we all have similar disciplines where settlement negotiations are frequent, and many cases are resolved by way of settlement negotiation. I think you have to toe that line to advising a client when you've got something that's seemingly in their best interest, while meanwhile conveying to them that I'm absolutely in your corner, I am your advocate, I'm 100% prepared to go to trial, fine. Obviously, there's a lot of CYA that happens there, especially if you've got potential post-conviction relief discussions. I always find that a little bit challenging to convey to somebody when you've got a great offer or potential resolution that's also likely going to save them quite a lot of money at hand. I have heard so many times it's not the money, it's the principle, until they get a couple invoices and then it becomes the money and maybe they get more reasonable. And I'm not suggesting using that as a tactic, but giving them an honest assessment of what the financial ramifications of each path on the decision tree is going to be, I think is a completely fair way of informing them of how the decisions ought to unfold. I am curious, and I don't know everybody's background here necessarily. Obviously, we're all in a litigation context. I know we have some transactional practitioners. We have all deadlines that are imposed on us by a court. You don't necessarily have those in a transactional practice. So I don't know if anybody wants to speak to that. Obviously, it's kind of an intimate group here this afternoon about communication, expectation setting, deliverables in a transactional setting. Mr. Peterson, would you like to speak to that?
We get to the microphone.
Yeah. It's obviously
off camera. I'll spit you like your headshot. How about that? Love this.
obviously a little bit of a different business.
No, well, thanks, Cal.
Good to be interactive.
I think the practice of law, no matter what practice area you're in, the same principles kind of apply throughout. I mean, I think no matter what, you still get runaway trains from a fee standpoint on transactions too. I mean, certainly if it's M&A deal or something where it is more adversarial or there's two parties involved, or sometimes it's not, you just have clients who, demand, more updates or more conversations or change their mind all the time or whatever that looks like. So I think just being, I agree with Tiffany, communicating before a big bill goes out or any invoice goes out is always helpful from an AR standpoint. And I mean, I think, even in situations where, I'm not a litigator. So as far as like plea bargains, et cetera, but, so much of, I can't speak for all transactional attorneys at our firm, Dvorak Law. A lot of our transactional attorneys get roped into litigation frequently because oftentimes we can be kind of the entry points to the firm. And if we are working with business owners or individuals who inevitably get sued or something happens, we're usually the first person they call. And so oftentimes, even if you don't want to be overly involved in litigation, you end up being involved throughout the whole process because when they are looking for updates, they have their relationship with you. And so that's what they're going to call. And so, being familiar enough with the cases that maybe you're not directly working on, but maybe you're the client relationship on. I think, Mallory mentioned a spreadsheet, just like periodically checking in, hey, what's going on here? Because, individual A called me and they want an update. And if I think I'm able enough to answer the, whatever the question is without bringing in a litigator or somebody else, I can do that. It's not a bad idea to let client calls roll the voicemail every now and then just to see what they're looking for before you pick up. And I do agree with, CYAing verbal conversations, whether it's phone calls or in person, with at a minimum like a memo to the file, even if you're not sending the communication to the client, because some clients don't like that. Some clients will know what you're doing. But at least you've got some memo to the file saying we talked on X date. Here's the strategy we agreed upon. Here's the plan of action. It's at the end of the day, it's we want to do what's best for the client, but the client is, it's their decision at the end of the day. So anyway, not if that's helpful at all, but from
Our fifth panels of the day.
Something something that I've gotten in the habit of over the past couple of years, and I'm having the rest of our criminal team do, is so the retainers we take typically get us to the point of like plea negotiations, and then it's if we're going to trial, there's going to be a new retainer. Not just saying, hey, I want, some round number additional retainer. I actually spend, and it usually takes 30 to 40 minutes, and you can't bill for it because you're talking about billing. And I break down, like, this is the attorney time. This is how much I'm going to spend preparing for trial times my rate. This is how much time Paul's going to spend times his rate. This is how much my paralegal is going to spend times her rate. Then we're going to do our focus group. And we're going to be in trial. We're each going to discount our rates by $100 an hour in trial. So that's going to save you this amount during trial. So I need $47,125 for trial and trial preparation. And that shows the client what's happening with that, as opposed to give me 50 grand for trial.
Sure.
So I think that establishes or helps establish some trust with the client that wow, they really do need this if they're going to go try my case. And that's been pretty effective for me in terms of getting ready for trial. And it also helps you prepare for, okay, these are the things I got to do between now and trial to get ready. So, yeah.
Sure, it feels a lot less arbitrary to the client too when they
Right.
receive a
A round number.
Yeah, exactly.
Yeah,
Would you
exactly.
with that?
Yeah.
Yeah, Mallory, that's exact same practice at our firm. We call it a litigation budget. This is what you are spending your hard-earned dollars on, and why we are charging you a large trial retainer, for your case. Dave, with respect,
Upfront, not after the fact.
upfront, yeah, well before trial.
Always.
For two reasons. One, you want to get paid before trial, right? And then two, the client needs to know what it is you're doing, with all of these hard-earned dollars before you go to trial. Yeah.
And there shouldn't be, just generally speaking, the business of law, we should understand better how much time is spent on things, how much money is being, charged shortcuts in this. It's a huge skill that we don't talk about. And by that education, or if somebody calls you and says, how long is it going to take me to do this, right? And maybe being open with how much time they spent on this so that we can understand this better and educate our clients better. Maybe it shouldn't be the secret sauce of like how much time to spend on this, right? We should, I'm thinking as bar association, maybe we should have more information and sharing on these different things.
Yeah, and I think the fear there is famous last words, right? Like, oh, this is going to cost X and it costs Y, and we weigh it. But again, I don't think that should be a detriment, though, to just being as upfront. Look, things may change, but based off of what we know now, this is our best projection, right? And, I think one of the things our firm does that's maybe a little unique is we have dedicated client service managers, right? The attorneys at Koenig Dunne, we practice law. And obviously, it's on us to be able to understand what's going on in a case, to be able to, relay to a client. These are the anticipated actions, the legal actions. So the other things that are going on that we need to think about too, right? But then we don't want to be the debt collectors with clients, right? And frankly, if we want to spend our time as attorneys having those meaningful client relationship questions, answers, guidance, right? Instead of, again, I need money from you now, today, yesterday, right? So we have dedicated team members who are the voice. And again, who can spend more time with the client too, just going through, this is, what a deposition is, if you haven't already covered that with David, right? And why it is that takes so long, and why, what the fees are that are associated with the transcript, whatever, right? But being able to help spend that time with the client, really break down bills, break down litigation budgets, and provide answers. And the one other thing I wanted to say too, Dave, with the CYA conversation, the question that underlines all of that, right, is what do you do when you disagree with what your client is doing, right? I know when I first started practicing, I always thought that, look, it's my job to educate the client. These are very reasonable human beings, have gone to school, right? They read, write, English, whatever, right? If I do my job teaching them, this is what the outcome of your case is going to be. No reasonable person could ever disagree with, my advice, right? Like, well, you are going to go to trial. You are going to spend a lot of money. You are going to lose. You are going to be unhappy. This is a great settlement offer. This is better than you will get going to trial. Let's do it, right? No. I don't think you heard me. You are going to trial. You are going to lose. You're going to spend a lot of money, right? Why aren't you doing and I always used to think, I must not be doing my job explaining and educating the client well enough on what the consequences are. And I found that that's not true. Reasonable people can disagree. And I mean, the client should be given that option. And it's on them to choose. So our job is to educate, give them the best person, in my experience, this is my best guess, in numbers. I always, give them a percentage. Because if you say, I think you've got a good chance or a bad chance, they hear, I'm going to win, or I'm going to lose, which may not be true, right? But just educating them as best as we can of this is my crystal ball and what I see. These are your options that I see. What other options do you see? Let's make the best decision we can. And if I really think you're doing something wrong, right, maybe it's still within the realm of reasonableness. I do my CYA letter, right? If I think you're doing something that is just so horrifically wrong that there's no way anybody could see me doing anything other than committing malpractice, then it may be a withdrawal conversation, right?
That's the next thing we chat into here. Dissatisfied clients, what you do with them, and if there's a withdrawal, Myrick that needs to happen, and when to pull the plug on the
I'll go first because mine's probably very different than the rest of everyone's. I mean, we do as much screening as we can up front because your criminal defense, you're in for a penny and for a pound. It can be very hard to get out of a criminal case. It can happen, but you usually need like a pretty good ethical reason to get out.
Those are less likely to.
Yeah, I mean, particularly like depending on how far some places it's like, no, you committed. Like if you didn't get paid, sorry, you should have got more money up front. Oh, will you appoint us instead? I mean, I've seen that happen before. Nope, sorry, like you shouldn't have taken that case for pennies on the dollar, a federal case. That I've seen that happen to attorneys before, but we really try and like screen up front, and that's why boundary setting at the beginning and things like that is really important because it can be really challenging to get out. But we have an in-house ethics counsel, but so we anytime we do reach a point where we think we have a reason to withdraw from an ethical perspective, we're talking to him, we're calling down to Mark Weber and documenting the file with respect to that. And you guys can probably get out of cases a little easier if they're not like set for trial, but yeah.
I think it's certainly simpler, but I was going to make the exact same point. I think you need to back that process way up.
Yeah.
These are all experienced practitioners, all at reputable firms. We're in the people business, and at that initial consultation, and I think you need to develop that instinct and trust that instinct because not always, but 90% of the time, it's the people where your paralegal comes to you and says, I told you that they were going to be the problem client. I think once you get firmer and further along into your practice and you have maybe a little bit more confidence and have a better developed book of business, you're more able or willing to say, thank you, I just don't think this is the right fit at this point, to save yourself some of that heartache and frustration down the road. That's hard to do if you're 1, 2, 3 years out of practice and you're trying to do anything to make money and to encourage billables for your firm, develop your own reputation, book of business, etc. You only have so many hours in the week. You want to work with the people that value your service. Otherwise, you ought to be at home pursuing your hobbies, your interests, your family, your passions outside of the business of law. I think part of the reason that we probably all practice in the geographical area that we practice in is because we do value that. Not that we're all highly esteemed professionals and care about our work product, but I and all of us, I know, have a life outside of this. So if I have X amount of hours that I want to work in any given week, month, or year, let's trust our instincts and work with the people that I want to be in business with. Because it can be a serious long-term partnership.
I think that's a phenomenal point, is that whether you're a year out or decades out, if there's red flags, it's like no amount of money is worth it because it's going to cost you in the long term.
Have your list of those questions and for answers are a certain way.
Yeah.
And here's another kind of oddball point too. I have noticed, I don't know if this has been your experience, I'm curious. I could sit in a room I remember the very first time I was 2 years out of law school, somebody asked a question to me, it was just a one-on-one consult, and I responded to them, and I took a deep breath at the conclusion of my response, and I thought, oh, that was actually decent advice. And that's advice that somebody ought to have been paying for. Similarly, if you're a younger practitioner, you may be frustrated that you're going to offer your insight to a client and it's not going to be well received. Then you pull in somebody else in your office who has some gray hair, and they're going to offer the exact same advice, and it's going to be received very differently. So as you're a longer tenured professional, you start to develop the benefit of some of that. And maybe I have had instances myself where you pull in somebody that says, no, this is look, I hired this person because I trust them in my office. You ought to listen to them, and I completely concur. So have somebody back you up in that communication if you potentially get crosswise with a client. So
I would, I'm going to echo, almost all of that. I do think that, it's really important from the get-go, if you see, red flags, or if you think that the client's going to ultimately have an issue with paying down the line, just kind of based on your initial conversations, ask for a significant retainer, because if they can't pay that up front, or they have problems paying that up front, then they're likely going to find another firm. Kind of the same, what Mallory said earlier, you get what you pay for. So, if you ever have a red flag or a concern, typically what we do is we just ask for a higher retainer. And you kind of know from the get-go, if it's litigation and, you get 1 bill out, 2 bills out, 3 bills out, and they're complaining about costs or what you're doing, your strategy, then it's better to get out earlier, and courts are going to always look at you more favorably for getting out earlier than it is to get out a week before trial when you're having a disagreement with your client, because in that case, the judge is likely going to say no. I have never seen a judge say, in the discovery process, hey, we need to get out, there's a dispute with the client relationship, and, if it's early enough where the client can get another attorney, I've never seen the judge say no in that situation. So that's kind of, getting the expectations up front, I think is really important, and the retainer is important for that reason, just to kind of make sure that the client is going to be one that you can have a good relationship with.
Most unhappy clients, don't happen overnight. Maybe a few, right? But I think if you have a client who is on the path to being an unhappy client, you usually know. There may be passive aggressive comments or just things that are said along the way. And I think the sooner that you can have the courageous conversation with them, be truthful, ask them, I heard you say this, that's concerning to me. Our relationship is built on trust, right? And if you don't trust me, no harm to me, but I want to make sure you have an attorney that you do trust, right? So just having that open conversation with them sooner rather than later, because things snowball down the line.
I think if you do have to get out and there's like an issue of refund and how much, I think at least early on in practice, the instinct can be, well, no, I did this much work, I'm entitled to this much money. Just be conservative and generous with it, because again, like, save yourself headache down the road. No, like, a few $1,000 here and there is going to matter long term, and save yourself headaches.
Mallory, that's a great point. So one really small tip that I've learned the hard way, right? If let's say you have that client that you absolutely love, that they're at the end of their financial resources, but they're not at the end of their case. And you just want to, it's a pro bono case, whatever. You just want to see this through the finish, right? Because you like this client. Do not tell them I will finish your case for free, okay? Tell them, whatever, my hourly rate is now $10 an hour, or something incredibly small that they can't afford. But just make sure they have some small piece of skin left in the game, or the case never will end, right? And you'll be on the hook forever.
That leads to a question here. Case management systems that you guys use when you develop practice areas. What do you use, and how does it help you with your clients?
We use, this is, our biggest client base is veterans. So our Berry Law has like 10,000 veterans clients nationwide. So we use the case management system that works best for them. Everyone else uses too. But I think that our personal injury practice really likes it also. The criminal is just not one size fits all as much, but FileVine, but it's a good, for us, we struggle because FileVine can't support like body worn cameras or Celebrite phone reports, like large things like that. So we have to have a separate system. So I think our criminal attorneys get frustrated because we're having to use, but in general, FileVine is really good. It's got all the client information. It's where the entire case is uploaded, contacts, and it's all like document generation type stuff, like some AI stuff. It's a really top of the line program. It's just, again, I don't think there's a perfect program for criminal defense, but I would say for almost any other practice area, it's pretty good. And it's if you're out, you're sick, something comes up, and a client calls in, it's going to be pretty easy for anyone who's totally unfamiliar with the case to look at FileVine in under a couple minutes and tell them what's going on. There's an activity log. You can let your emails dump right into it. It's a pretty neat program. Yeah.
I'll be the Clio salesman up here. But we
don't the cover of the magazine, though, are you?
Maybe.
One day.
One day, right. No, we have as a firm, we used to use Amicus, and then we switched to Clio, and we frankly we just love the change. So some of the features that we really love about Clio is it has document automation, right? Which, if you can have AI or whatever it is now, just automatically spit things out for you in 2 seconds. It used to take 20 minutes, right? You can intrinsically save your clients, money doing that, right? It's very user friendly. And so, a lot of it is what software do you have, right? But how do you use it? And so we spent a lot of time as a team training, retraining, and getting what I would call standards in place amongst our team about how we use this software. I mean, each attorney has their own unique flavor in our office of how they practice law, right? But just some commonality. So if I get hit by a bus tomorrow, right, all of the deadlines that are being tracked, all of the outstanding actions that are, that need to be done on a case, they're all systematized within Clio. And it's very easy to use, and you can bounce back and forth between attorneys at our team pretty seamlessly.
We employ a PI-specific platform that I'm not going to bother mentioning so they don't get any incidental advertising because I think it's average. But there's one, I think, aspect of it that is useful, and it's probably common to all of the practice management software out there these days, and that's the ability to text people. And I think it is hugely helpful and also potentially hugely problematic. I am constantly amazed that I will call somebody, especially oftentimes law firm numbers are kind of generic. So it looks like a generic business, and maybe that's a spam call. And there's so many high volume of spam calls anyways that people are unlikely to pick up a telephone call. And then you text them right after and they'll respond. And it's maddening, but it's just the way that we all operate in our private lives. So we shouldn't begrudge clients for that, I suppose. But I think you need to be very cautious, and them understanding that that's not a 24/7 connection to you, and that if you're thinking about them, you're going to be billing them. I've had some instances in prior capacities where people are surprised that emails or text messages or whatever are billed to them. And it's, I'm spending time communicating with you. This isn't a free 24/7 texting service access to me. So I think it can be hugely helpful. I've also found it helpful in communicating with witnesses or third parties to your case who may be disinclined to want to speak with you, maybe just have a general distrust or mistrust of lawyers, and are more apt to text. And then you also, of course, get that written record of what they're saying as well. So can be hugely helpful. If it's your client, I think you need to be very careful about the expectation setting with them on texting and understanding that that's going to be a billable service to them.
So we use primarily NetDocs. It's more like a document management system, but I think maybe each practice group, and I'll let Zach, if he wants to join this panel again, to kind of add on. Each practice group uses it a little bit different. So I would say, a lot of the information on, we also use the hit by the bus theory. So if somebody gets hit by a bus, you can go into NetDocs and figure out, what's the status of the case. Their invoices are there. Pretty much everything's there. The client, how to get a hold of the client. All the information is there. And the things about, billing, et cetera, all within there. But then each practice area kind of has something a little bit different. Like there's no calendaring really through net documents that we use. So we just do a lot of calendaring through Outlook, where we have reminders to talk to clients, reminders about court deadlines, with 2 and 4 week reminders on top of that. And we include just everybody who's tangentially involved in the case on those deadlines. So at least people are aware of what's going on. Other than that, I don't think we technically use anything that's, I don't know. Clio kind of sounds familiar, but, or kind of similar, but nothing that's essentially client management where, things are pushing out to talk to a client or giving automatic updates or anything like that.
That is the nice thing about FileBind does have all of that. So I guess I'll be the FileBind salesperson, which I never thought I would. Commission. But the DocGen is pretty cool too. You hit a button and your document's done. That's, it takes some work behind the scenes to get the documents put in and right, but once it's in there, and we've got, across the state, all the bailiffs, all the warders, all the judges, all their contact information is now just auto-populated in there. But
yeah,
I don't know. Right?
I had one topic I wanted to touch on. I know we're kind of getting towards the end here, and that's communicating to your client when you've made a mistake and it's potentially detrimental to their case or to their rights. I am not perfect. None of us are perfect. Perhaps you've never made mistakes. I have in practice. I would tell you, I dreaded it, for the entire weekend, but it was apparent that I had made a misstep in practice. Obviously, we have systems and people that help prevent us do that to the best of our possible professional lives, but it happens. I have communicated that immediately and directly to these people, and it has been greatly appreciated. And I think it, no question, has led to diffusing the situations. And when you show that humanity and just genuinely apologize for an error or misstep, that people are much less likely to want to seek retribution against you, assuming that's not a major detrimental or fatal error to the case. So I don't know if you guys have ever found yourself in that situation. I have.
Yeah, I think we all do. And I think don't be afraid. We all make mistakes. Nobody's perfect. And don't be afraid to reach out to your peers to figure out how to problem solve. Like, even, before you go to the client, like, hey, this came up, like, what do I do? Don't be afraid to talk to a counsel for discipline. Don't be afraid. I mean, the more people you talk to, the better you're going to problem solve when you do make mistakes, because it happens. Like, we're human, we're not machines. And
it's never as bad as you think it is at 3:30 in the morning.
Right.
It just isn't.
Yeah.
The saying "I'm sorry," and not necessarily that you did something wrong, but sure, it's a bad outcome.
Sure.
They talk about that in medicine for a while there. Sure, your malpractice chances would go way down just saying you're sorry, right? Empathizing, not necessarily admitting that something was wrong that you did. Sure, but that it's
Just don't say that if someone accuses you of a crime.
okay.
I'll tell you where that'll go. That'll go right into Exhibit 1.
Yeah. I think you need to be cautious about potential liability, certainly criminal liability. But owning that, and if it's an apparent mistake, then so be it. And I think diffusing that just candidly and empathetically can go a tremendous way to preventing that problem from going any further.
The real world of them knowing that you're human and showing you're human.
Yes, and obviously strive every day to avoid exactly the error that happens, but once a decade, you're going to make a misstep. And I think communicating that quickly and honestly and openly is the way to go.
So in terms of feedback that you're getting from clients, either during or after representation, any systems in place for that, or ways that you're bringing it back into the practice for future work that you're.
We have like some systematized, like, are you talking about reviews and stuff?
Yeah, it could be official reviews. So you guys could be doing internal reviews or feedback from clients.
Yeah.
Maybe we should be doing more of that, and we don't necessarily want to hear bad feedback, so we don't ask for it. I don't know.
We ask for 5-star reviews. I shouldn't say it. We don't ask for 5-star reviews. We ask for a review, and we hope that they'll be 5-star. And we get client testimonials and things like that. And I find that, if you are the type of firm where you're doing that for, your bio or your marketing or whatever, our firm has some systematized ways to do that to help cut down on attorney time. I don't do it that way. I always contact the client directly and just say, hey, if you're willing to leave a few comments on, to the extent that you're doing that for marketing, I think that it works best when you just carve out the time to send in it. I form pretty serious relationships with my clients because I'm with them a lot. So if they were to get some automated, please leave it, they would be like, no, that's not how Mallory talks. There's no cussing in this email. So in terms of that type of feedback, I find that an individualized personal request usually is the highest success at getting something back.
So we have a system where we do a mid-case survey for our clients, and then we do a 6-month post-case survey to get feedback. Feedback is necessary in our line of work. You have to know what you're doing well to duplicate it. You have to know what you're not doing well to make changes, right? To get an email, some clients will, some clients won't fill them out for the survey. So at the end of every single case, I always have a final phone call with all of my clients, and I always ask them, what did we do well? And what didn't we do well? And I always thought I want you to be blunt and brutally honest with us, right? And it works. And then you get actionable feedback that then you can take back to the practice and make better.
Yeah, I think that's, if you're a public-facing private firm, that's the reality, whether you like it or not, is if somebody doesn't have relationships with an attorney or has no experience in the realm, they're going to go to Google, probably. And I think we've all done it for a service that we don't have any personal referral. I think the personal referral or recommendation is still the gold standard. But there are we live in this small little universe where we know a lot of lawyers, and you forget that most people don't if you continually socialize with lawyers and work around lawyers all week. And that most people don't have those relationships, and they don't know where to trust. I agree with you. Making that personal ask as opposed to sending them a text message later, they're going to just ignore it for the most part. I think at the conclusion of the case is appropriate. You know the people that you're not going to ask.
Yeah.
Because it's not going to lead to. Yeah, absolutely. And then I guess conversely too, if you get unfavorable comments or remarks from somebody, it's happened to me on a couple of occasions. Again, mea culpa. And I have just called the person, addressed it with them, apologized to them where appropriate, and they've either gone back and retracted it or revised it, and indicated that I've called and made it clear, whatever. I think that's a great thing to do. Again, not pleasant, and you could just dig in and say, you didn't appreciate all the good work I did for you, blah, 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 and move on. But I think if you do take 5 minutes and openly address it with them, that oftentimes you'll find they're willing to reverse course on it and leave you some positive remarks.
So typically, what we do not ask for straight up reviews. It's kind of our perspective that the best review is either return clients. Being in the commercial world, it's easy to get kind of return clients, whether it's for their personal estate plans or something else with their business. Litigation, not so much. You don't want them to return to litigation generally. But if you get, you represent a business in litigation and they're happy with your work and they come back and they ask you for something else, whether it needs to go to the transactional team or somebody in estate planning, that's one of the best reviews we can get. Or they refer you to, another business, and the business says, hey, I heard you were representing X in this litigation, or hey, I heard you did this for this business, and I'd like you to do the same thing. So that's typically how we approach the review network. We obviously have clients who are unhappy, and we try to address that from the get-go so that they're not going to go around and badmouth us. Or badmouth specifically the legal work that we did or anything like that, just to try to bite that off. But we don't typically ask for, Google reviews. And I'm sure, we probably have gotten bad Google reviews in the past, and you can typically tell who it is, and going and, kind of as you said, Kyle, going and addressing that and talking to the person, I think is probably the best approach to do that. But I have not necessarily seen that personally myself. So
the most authentic feedback I have ever gotten is from jurors after jury trials. I mean, I really, you learn the most from the ones you lose. So like taking the time to listen to what the issues were is really good. So if you ever have jury trials, talk to the jury when you can. Yeah.
That's right. I'm out questions. I'm not. I'm never. We're at there. But I want to see if anybody in the audience has any questions they want to ask, or if there's anything in their panel wants to add to this. Our fifth panel, Sam, any question?
I guess the only question I would have is not a question, but kind of how your firms. I mean, we all have like a skill set, right? Our firm probably has a little broader skills, and you work at a, fully business-based firm, but we don't do criminal law, we don't do divorce work, we don't do personal injury. So, I know we've worked with attorneys at all three of your firms, but I guess how do you approach that? I guess when you realize pretty quickly that, somebody referred a client in that's outside of your skill set, and your firm can't handle it. What does that process look like for you? Because I think for us, I guess that's the value of like the OBA and the NSBA for us. It's like having relationships, because we don't want to do anything I just mentioned, right? So for us, that's almost like another referral pipeline. Is if we send work out, not we're expecting work back, but we know that kind of work relationship benefits lines. Anyway, whoever wants to dig that, how do you guys screen, I guess, when work comes in? I'm guessing, very rarely does somebody call you, Mallory, and say, I want my estate plan done.
Yeah. So we, again, and this is the benefit of having this huge veterans practice. We have an intake team of, at least a dozen people, and all they do is answer phone calls. So there's intake people specific to criminal, specific to personal injury, specific to veterans. And so they, and they're all trained. We have a sales attorney, and then they have a supervisor, and so they get together and train weekly on like updated SOPs, and so they have screening questions. So and then they have attorneys throughout town to refer for different kinds of subject matters. So and that just gets added to every time. It's like, oh, here's somebody else would want to add to, divorce law, like these are the divorce attorneys that they want, so our intake team usually is able to cut that off or any event, I don't know the last time somebody actually made it to me wanting help in a divorce case. Usually the only stuff that slips through the cracks is like civil defense, like falsely accused, but civilly. And it's like, I don't do that kind of stuff. So, yeah. Yeah. So intake team screening questions ahead of time, getting that to, I don't know, to the extent that people's receptionists or whoever is answering the phone coming up with like, here's referrals for these types of cases. Here's a few screening questions you can ask so that, attorney time's not wasted but the person can still get sent to the right place.
Yeah, very similar process at our firm. We have an intake team too, and if it's just not a match for our firm for whatever reason, right, then usually we're trying to refer out, right on the phone call to that person calling in. The other question there, though, is what if we get a very unique divorce, right? With I'll give you an example. Let's say there's an irrevocable trust with the entire estate in it is worth $100 million, right? And there's 18,000 businesses that are a part of that. What do we do then, right? So I think you have to have recognition, like, is this something that is so far outside of my practice area that I need help? I need support. I need to get outside counsel in to come and help me. And we do that. I wouldn't say frequently, but it certainly does happen where if there are, very unique business issues that pop up, we'll retain or partner with a business attorney for that client. I've had other where there may be some different type of civil litigation that is connected to the divorce, right? So we'll partner with a civil litigation attorney for those type of issues. But it's just the recognition that, there are other issues at play here that we're going to need outside help for. It's just recognizing that and taking action.
Like you had mentioned earlier, Zach, when you undertake a matter for somebody, I think we underestimate the intimacy of that relationship or the importance of that relationship to that person. You do somebody's trust, you've done 100 trusts this year, 2 years go by and some issue arises and their daughter gets a DUI in Arizona and they think to call you. I think that's true of all of us. I have clients that call me years later on matters that are way far afield from anything that I've ever undertaken, that I ever want to undertake. And so having certainly that roster of people locally that you entrust because you're, essentially vouching for them and the competency of the service that they're going to provide, I think is huge. And understanding that, even though this isn't your area of practice, making them understand why and then making that handoff to somebody that you trust is obviously huge. And being involved in organizations like this and coming to events like this helps you develop that network of people that you can entrust you. If I get a divorce client, I'd be very comfortable saying, hey, you don't want me anywhere near your divorce, you're going to end up penniless and with no custody, but let's call it. There's the sales pitch. I think making that handoff capably is pretty key, and just appreciating that you have a profound impact on somebody's life in that way, and to kind of pull it all together, I suppose that, if you're not a business, you're very seldom or hopefully not involved in the legal process very often. And this may be the one case in this person's entire life, and that's why they feel so profoundly and so significantly about it. And appreciating that, and that's a continuing relationship, at least in their mind, even though the engagement's over years ago. Thank you.
And I don't have anything to add because you kind of explained what we do. I guess one thing I could add is, in each, what we typically do is if it's a really niche matter, and we will always shoot emails out throughout the firm to make sure that it's a good recommendation or referral. And we try to make sure that it's, somebody the firm trusts, somebody that somebody's used before, somebody that people know personally. So we do get emails like that a lot, whether it's in-state, out-of-state, hey, we're looking for somebody to do X, Y, and Z matter for one of our existing clients or even a new client that we just don't really handle at the firm. So that's one thing that we will do quite often, and it is nice to have the relationships established on what everybody does and really what kind of law you practice. And that's why I think it's important to remember that Omaha's a small legal community, and you should really be nice and courteous to whether it's your opposing counsel or just people at events, because you're likely going to end up dealing with that person in future. So
don't agree with problem clients. Thank you for that.
One thing we've done too is we've gone into some civil firms and done like a free 1 hour CLE on like what to do if you have a client accused of a crime. Cause like a lot of people don't, like, okay, wait, the police just called you or you're calling me from jail right now, and we've made a lot of good connections that way. And we've learned a lot about the people that we're going in and talking to, just like, oh, you do this area. Well, I didn't even like know that was a thing. And now I have someone to refer to. Likewise, like we had an immigration attorney from Coley Jessen come in and do a 1 hour CLE for us because a lot of our clients have immigration consequences. So like going into firms and meeting people that way and just, hey, this is what I do. If you have people interested in an hour of my time, happy to come in. And, it's a good way to kind of make those connections. And
Makes a lot of sense.
yeah.
Any other questions? All right. I think we might have gotten an extra quarter of an hour out of it, everybody. Congratulations. 1.25 hours.
Thank you so much.
Yes.
Quiero yo hacerte el amor,